you have every right to represent yourself without a lawyer. And so it is not compulsory that when you are charged and put before the court, you must necessarily have a lawyer. You have the right to any lawyer of your choice, but you also have the right to represent yourself. And this is perfectly captured in Article 19 of our Constitution. So, with your permission, I'll read a few portions of Article 19. If you read Article 19(1), it says that a person charged with a criminal offense shall be given a fair hearing within a reasonable time. Then you look at Article 19(2)(e). Let's go to 2(e), F, and G.
Yeah.
2 says that a person charged with criminal offense shall be given adequate time and facilities for the preparation of his defense. So the person is that when you have been charged with a crime, the law says you should be given adequate time and facility to prepare your defense.
Yeah.
When you go to 2F, it says that a person charged with criminal offense shall be permitted to defend himself before the court in person or by a lawyer. So in person means that you can decide to defend yourself, and it happens all the time. In fact, a lot of people go to court without a lawyer. The law is saying that you can defend yourself in person or by a lawyer. Then we go to 2J, Article 19(2)(J).
Yeah.
It says that a person charged with a criminal offense shall be afforded facilities to examine. Again, here too it says in person or by his lawyer.
By his lawyer.
The witnesses called by the prosecution before the court, and to obtain the attendance and carry out the examination of the witnesses to testify on the same conditions as those applicable to witnesses called by the prosecution. So usually in prosecution, the prosecutor will call some witnesses to come and testify against you. Article 19(2)(J) here is telling us that either you, the accused person, personally, or your lawyer should be given the chance to cross-examine the witnesses who are coming to testify against you. And so whether you have a lawyer or not, the court will go on. Of course, a lot of the time, the court gives deference to the right of the accused to get a lawyer, because the courts are very much aware that for most people, when you are given the chance to cross-examine a witness, you may not be able to ask the right questions because you may not understand the law enough to be able to ask the questions that will expose the weaknesses that are needed to defend your case. And so when you have a lawyer, it gives you that upper hand to be able to ask the right questions that will expose the witness if indeed the witness has come to lie against you. But that does not prevent the court from deciding to proceed with a trial if you don't have a lawyer. And so most of the time, if let's say you have sacked your lawyer or your lawyer has died or resigned, the court will give you 1 month or 2 months to go and look for a new lawyer. And if after some time you are still not able to produce a new lawyer, the court will continue the case as if you had a lawyer.